Good evening. I'm Lonnie Screntner, Vice Chair of Clean Elections Minnesota, and an active member of the League of Women Voters, the co-sponsors of tonight's program. Thanks to each of you for zooming in to tonight's program and for being willing to work to better our democracy. Clean Elections is a nonprofit, nonpartisan organization that supports enacting laws limiting the power of big and dark money in political campaigns, as well as making our voting as easy and as accessible as possible. We also sponsor events like this one to inform, educate, and activate citizens on related issues. Tonight's co-sponsor, the League of Women Voters, also encourages informed and active participation in our government and works to increase the understanding of public policy issues and active participation in government. Tonight's program is meant to inform you on how Minnesota will be redrawing our congressional and state legislative districts based on the results of the 2020 census, and how you can be involved in that process. The Constitution requires this redistricting based on the census every decade. To be an active participating citizen in this process, after tonight, go to lwvmn.org and scroll down on the homepage where there are links to redistricting. Our featured guest tonight is attorney Peter Wattson, who has been involved in every Minnesota redistricting since 1970. He served the Minnesota Senate as Chief General Counsel, and in 2011, represented then Governor Mark Dayton on redistricting issues. Peter is the lead plaintiff in a present lawsuit filed last February that the Minnesota Supreme Court used to consolidate all redistricting challenges into one case. Peter is a graduate of Harvard University and the University of Minnesota Law School. Recently retired, though she often still writes columns, Star-Tribune reporter and columnist Lori Sturdevant will be interviewing Peter tonight. Few people know more about Minnesota politics than Lori. She might not want to admit that she's been doing this for over 40 years and has written and edited 11 books on Minnesota's leader in politics. Lori is a graduate of Coe College. We're eager to have you involved and engaged in this conversation. Please submit your comments and your questions as Drew described earlier. Lori and Peter, it's all yours.
Well, Lonnie, so nice to be with you. Thank you for that very kind introduction. And what an honor it is to be with Peter, the guy that I used to go to when I was working actively for the newspaper many, many times to learn about redistricting. You know, Peter, redistricting is one of those things that is fundamental to our democracy, to its fairness and its good functioning order. And yet it's because we only do it every 10 years or so, and because we don't ever seem to quite do it by the books in Minnesota. It's a complicated thing for people to get their heads around. And it's something that I think right now, at this very moment, it's fairly crucial for those of us who are stewards of democracy to pay attention to. Peter, thank you for being with me tonight, and thank you for putting together a slideshow, which is going to make my life easier and our viewers better informed. Take it away with that slideshow of yours.
Thank you. I think you can probably see me up in the corner of your screen, but I do want to thank Lonnie for helping to put together this program and for that kind introduction. Thank all the people at Clean Elections Minnesota for what they have done to bring us all together tonight. And thanks to all of you for taking the time to zoom in and listen to Lori and me talk about redistricting. As Lori said, she has given me hints of what her questions are going to be. And so I put together a slideshow. This is the first slide. We'll see if we can get to the second one. I'll tell you a bit about the breadth of the slideshow. The first two bullets are what Lori and I are going to talk about, why government redistricts and why citizens should care about it. Then the balance of it is more details on what's going to be happening over the next several months. That's material that you may ask your questions about when Lori and I are done with our conversation.
Well, yes, and
So-
we really welcome your questions. So please do submit them. I always love to know what's on people's minds about this. Peter, let's start with some definitions. We hear different terms: reapportionment, redistricting. There's that other term, gerrymandering. Tell us about these terms.
I'm so glad you asked. We do need to distinguish between reapportionment and redistricting. Reapportionment is a process of assigning seats in a legislative body among established districts. The district boundaries don't change, the number of members per district does. That's what we do with the US House of Representatives when we are assigning seats in the House to the several states. The boundaries of the states don't change, but the number of members per state changes. Redistricting, on the other hand, does involve changing those boundaries. Each district still has just one member, but the coverage of that member, their territory, their constituency changes as the district boundaries change. And why might district boundaries need to change? The first reason is because of that reapportionment of congressional seats. Every 10 years, we take a new census, and every 10 years, we see in the last many decades, the population moving from the Northeast to the South and the West of the country. And we see seats moving from a state like Michigan to a state like Montana. Now, since Michigan will have one fewer member, they need to have one fewer district. So they're going to have to redraw those boundaries. Montana currently has only one representative, so they just have the whole state. Now they're going to have two. So they have a commission that will draw those district boundaries. That's what happens every 10 years. But what about the states like Minnesota, where the reapportionment doesn't change the number of their congressional districts? Do we even need to bother? Well, yes, we do, because of population shifts within the state over the decade. It's a fact of life in redistricting that absolute numbers tend to be less important than relative numbers. So when we get the new census, and I'm going to show you a slide of that in a moment, showing how many people are in each of Minnesota's current state house districts, we'll see that some have grown faster than others. Some have shrunk. So it's not the population, the absolute population of any house district that matters. It's whether the population has grown faster or slower than average, whether the population now is above or below the ideal. For those districts where the population growth has been slower than average, they're going to have to grow in area in order to take in more people. For districts that have grown faster than average, they're going to have to shrink in order to take in fewer people. What's that going to look like? Well, here's the 2020 census and the population of each of Minnesota's 134 House districts. The colors, green and brown, show districts that are either underpopulated in green or overpopulated in brown. The darker the color, the greater the degree of departure from the ideal. So you can see up there in northern Minnesota, there are an awful lot of districts that are going to have to get larger. Well, they're not going to go into Canada. They're not going to go to the Dakotas or Wisconsin. They're going to move south toward the Twin Cities. Same thing in southern Minnesota. You see that there are some dark green districts, very dark green. Those three sets of districts you see down there are more than 10% below the ideal population. They're going to have to grow even more in area than the ones that are in a medium green. But they're not going to go to the Dakotas. They're not going to go to Iowa. They're not going to go to Wisconsin. They're going to move toward the Twin Cities. What does the Twin Cities look like? Well, whoops, got to go back. The Twin Cities are where all those districts are going to be moving into. And you see that a lot of the Twin Cities, the far suburbs up here in Anoka County, Washington County, Wright County, they're white. These are districts that are within plus or minus 1% of the ideal population. They wouldn't have to change, except that they're neighboring districts that are going to have to get bigger. So these districts are going to move into Anoka and Washington County. These districts wouldn't have to change at all out here, except that this district is going to shrink and this district is going to shrink. And here in Carver County, they're going to shrink a lot. Fastest growing county in the state over the last decade. What you see is that the result of these population shifts is going to be an awful lot of activity in the metro suburbs. Little surprise here. Downtown Minneapolis, along the river, all those apartments you see along the river, those districts are now well above average, more than 10% above average. What's that going to do to the political geography of the state? Here's what those House districts look like in 2010, showing which party, Republican or Democrat, won a particular precinct. The Democratic precincts are in blue, the Republican precincts are in red. The deeper the hue, the higher the degree of win. You can see that we've got our northeastern Minnesota Iron Rangers, very blue. You can see in the Twin Cities, there's an awful lot of blue. In the rural areas, there's a lot of red, but there's also mixture of blue and some white districts, very close districts. What does it look like 10 years later? Well, that smattering of white and blue in central Minnesota here, it's gone. This is all red. And although there may have been some red areas around the center of the Twin Cities, they're gone. This is all deep blue. You can't draw a Republican district in this area because there are no Republican precincts. Likewise out here, you're not going to draw a Republican district out here. There are no Republican precincts. The state has become more polarized over the last decade than it was 10 years ago.
Well, Peter, that that leads us right to the question that you and I talked about at some length. Why do we care about this? Maybe it would be well to talk a little bit about the history. There was a time when it seemed like Minnesota didn't care about this. We went almost 60 years, 55 years or so without adjusting these maps. Now we do so faithfully because the federal courts have insisted. But what difference does this make to average citizens?
Well, assuming that the courts are going to be involved one way or the other to equalize the populations that we just saw are not equal, does it make a difference where those boundaries are drawn? And I would submit, yes, it does, because depending on how the districts are drawn to equalize their populations, some groups may not have an equal opportunity to elect candidates of their choice. Different kinds of gerrymandering. Gerrymandering is drawing districts to give the people who are drawing the districts, the masters, the majority, an advantage in elections. And back in the 19th century, there was a lot of gerrymandering by rural districts who controlled the Minnesota legislature. And we'll see more about that a little bit later. Rural versus urban. Since the 1960s in particular, there's been a lot of racial gerrymandering in order to deny African Americans in particular, but also Hispanics and Asians, the ability to elect representatives of their choice. And from the beginning of the country, we've had partisan gerrymandering where Republicans and Democrats try to draw districts in a way that the other side won't be able to win. So if we're going to have fair districts where various communities are given an equal opportunity, we need to care, because if the legislature were left to its own devices, it would not.
Well, and gerrymandering is a term that sounds vaguely nefarious in all its forms, but in fact, the courts have outlawed some kinds of gerrymandering and not others, right?
Correct. The racial gerrymandering was outlawed by the Voting Rights Act of 1965. And every decade since, there have been lots of lawsuits challenging redistricting plans as racial gerrymanders, and many, probably most, have been successful. But partisan gerrymandering, although it has been pervasive over our history, has not been subject to successful challenges in state court until this decade. People began to be able to sue on partisan gerrymandering grounds in 1986 with a Supreme Court case of Davis versus Vandemer. But although courts, litigants attempted to develop a standard for determining whether a gerrymander was valid or invalid, they were not successful until really the first case in Wisconsin in 2016 called Whitford versus Gill, where the Wisconsin legislature had drawn their assembly districts so that by 2018, 46% of the vote went to Republicans and 64% of the seats. That didn't seem right. So they sued, and the plaintiffs were successful in getting the district court to throw out that plan as a partisan gerrymander. There were other successful cases in Pennsylvania and North Carolina, Michigan, Ohio, Maryland, where the lower courts threw out plans. But in June of 2019, the US Supreme Court, with an opinion written by Justice John Roberts, said, oh, we don't think federal courts ought to be in the business of policing partisan gerrymandering. There are no standards in the US Constitution, and there's no federal law creating a standard for partisan gerrymandering. We think federal courts have no business in this. Congress could do something if Congress would pass a bill. The states can do something. In fact, the states have been doing things. Why? Take a look at Florida. Take a look at Pennsylvania. Take a look at North Carolina. They've got some standards there. They've been successful at the state level in the legislature and constitutions and in lawsuits. Follow the state example, but stay out of federal court.
Okay.
So the Pennsylvania Supreme Court threw out the congressional plan in Pennsylvania. The courts in Florida threw out the congressional plan and the Senate plan and had them redrawn. The court in North Carolina, having been told that the federal courts could not do this job, said, let's take those arguments that were made in federal court and we will apply them using our state constitution. And we will find language in our state constitution that says, yes, partisan gerrymandering is a bad thing. And under North Carolina law, you can't do it. And so they threw out both the legislative plan and the congressional plan, a state court did, and they had to be redrawn. So the action is in the states as far as partisan gerrymandering goes, not in the federal courts.
But I think, as we will see later on, the Minnesota legislature has been rather good at avoiding this whole topic. We'll talk about that in a little bit. Peter, what do we hope that this cycle's redistricting, well, this redistricting in general, but what do we hope redistricting will accomplish?
What do we want to accomplish? Well, if I get my way, and I think if the Clean Election Minnesota gets its way, we will have districts that provide for fair representation for all citizens. We will take a look at where minority groups, racial and ethnic minorities live, and how many votes they have, and what it would require to give them the opportunity to elect representatives of their choice. We will get testimony, as the House Committee has been doing for the month of August and September, from citizens saying, what other cities do you want to be together with? How is the current district alignment working for you? Do you want to keep the district about the way it is? Do you want to change it? We get citizen input on who should be together and who should be separate. If I get my way in my lawsuit, we will have a situation that the political party that wins the most votes statewide will elect the most members to a legislative body. That's my standard that I am presenting to the state court.
And that's been kind of a measure in other states, hasn't it, of a badly gerrymandered situation, where you have example would be Wisconsin, where Joe Biden won the presidential race in 2020, and yet I think something like 62% of the legislative seats are held by Republicans. That's sort of a litmus test for gerrymandering, is it not?
Well, that's my test.
Okay,
That's my test.
and you say that a proper redistricting plan should not allow that to happen.
Correct. Yes, I would say it is not fair.
Okay.
And I'm proposing to the court that they adopt a standard like that. I don't know that they will, by the way, because the courts, not only in Minnesota, but around the country, have very much tried to stay out of the political thicket. They don't want to get involved in questions of partisan advantage. It has taken from the beginning of the country until 2016 before any court stepped in and said, this plan is bad because it's a partisan gerrymander. But in the time since Whitford versus Gill, through the end of 2020, there were a number of cases, I rattle off the states where courts threw out plans, and they developed these standards for deciding whether something is an invalid plan or not. And these are the standards that I'm proposing to the state court for its adoption. But they may not want to get into this business at all. They may take the position that some people do. And at some points, I think both Clean Elections Minnesota and Common Cause and the League of Women Voters, I think they have all taken the position, let's stay out of politics, draw the lines without any information about where incumbents live and without any information about how the districts will perform politically. That is, we don't want to have election results in our database. But they're changing. I've been trying to persuade them that that's not the best way to go, that you can't just tell a bad plan by its shape. You have to take a look at the statistics, the election results. And there are ways, there are formulas you can apply to the election results to tell whether they are producing a fair result or not.
Well, this is maybe a good opportunity to ask a question that's already been posed by one of our listeners in the Q&A. Have we got a gerrymandered plan in force now by the very measure that you describe? Is Minnesota already a gerrymandered state?
I have applied my formulas to the current plan and the plan that was adopted in 2002 by the court. Mm-hmm. And both of those plans have a Republican bias. And indeed, the plans that I have drawn, and some of you have seen the plans that I have drawn, and you've seen my partisanship report that shows how they stack up. They've got a similar partisan bias toward Republicans. There is a natural bias for Republicans in the state of Minnesota under that political geography that you just looked at.
Right.
Where their strength, their voting strength is more evenly distributed across the state. So that they win all those red districts, yes, but they're not winning them with 80% of the vote. Maybe they're winning with 60 or 55% of the vote. So they are not wasting as many votes as Democrats do when they win districts in Minneapolis and St. Paul with 60, 70, 80% of the vote.
I think that there'll be people in Minneapolis and St. Paul who will not like hearing that those are wasted votes, Peter, but I understand what you're saying.
Well, yeah. Wasted votes actually is a concept that was developed in the Whitford case.
Yes.
And it was developed as part of a measure called the efficiency gap. Uh-huh. And it takes all the votes cast for a losing candidate, plus all the votes cast for a winning candidate in excess of one more than the loser, and says those votes are wasted, and counts them up and see how many votes are wasted by Republicans, how many votes are wasted by Democrats in a plan, and then gives you a number of the percentage of the votes that have been wasted. And the difference between Republicans and Democrats, that's the efficiency gap. And my report shows that, and the efficiency gap for my plans is not that much better than the efficiency gap for the court plans.
Yeah, because it's very difficult to if you go back to the slide of yours a few slides ago, showing that very red map with the very blue dot where the metro area sits. We are a very polarized state right now, and that makes it very difficult to draw districts that don't have this inefficiency problem that you're describing.
Yeah.
Yeah.
But if some party in this litigation submits a map that is even more biased for Republicans, we'll see it. Yes. We'll see it in the measurements.
Well, let's talk a little bit about about the history of all of this before we open it up more to other questions about our current situation. I've always struck by the perversity of the situation that the legislature has been given this responsibility, and yet for most of the state's history, the legislature has failed to shoulder that responsibility, that the courts in Minnesota have been the drivers in all of this. Your lawsuit this year reflects that supposition that the courts are going to be drivers again. What goes on here, Peter? Why does the legislature always seem to fail at this?
Well, there's the general factor going on that whatever state you're in, the political interests who are in power don't want to let their power slip away just because the population has shifted to other parts of the state. Minnesota, as you may or may not remember, was initially settled by people who came up from Illinois and Wisconsin into southeast Minnesota, and then they worked their way up into central and northwest Minnesota and worked their way into the Twin Cities. Well, I've seen a lot of newspaper articles from the late 19th century, 1880s, 1890s, where there are complaints that the Minnesota legislature is badly apportioned because the people in northwest and central Minnesota don't have their due. And the people in southeast Minnesota are saying, oh, no, this is fine. It's always been this way. We wouldn't want to have too much change. And that's one of the reasons why the legislature first began to delay enacting their plans in the late 1880s, 1890s, and why they stopped enacting plans after 1913, because power was slipping away. After we got into the 20th century, it wasn't just groups of farmers arguing over which farm group is going to be more powerful. We had the development of more urban interests, and all rural interests. It might not be farmers, it might be farm processing people, or it might be small manufacturing plants or mining or whatever. People in the rural areas did not want to cede their power to those nasty people living in the cities who were growing in population faster than the rural areas. By the 21st century, since 2001, we've gotten accustomed to the legislature not doing its job and been relatively happy with the job that the court has done. It's really easy for the legislative leaders to say, whoa, it's not my fault you have such a terrible district representative. It's the court. Blame them. Don't blame me.
That's right.
There are additional reasons. In the Minnesota legislature, and I'm not sure what the situation is in other legislatures, they treat a redistricting bill just like any other bill. They start in their 4 caucuses, drawing their plans, each leader seeking the support from all of his caucus members. Then they work the bill up to the floor, and the key test is, can we pass this bill out of this body with only the votes of our members? So they're not working with the minority to get a bill through the body. That's not their worry.
Of course, the other thing we've had in Minnesota is we've had a history of divided government in St. Paul. And that also has contributed, hasn't it, to the failure of the legislature to take this responsibility on in a serious way.
It's a curious accident that in every year when it was necessary to do redistricting from the 1950s forward, we've had divided government, where the House, the Senate, and the governor are not all controlled by the same party. There have been years within those decades when, yes, Republicans controlled everything a lot in the 1950s and 60s, and Democrats controlled everything in parts of the 70s and 80s. But whenever it came time to pass a redistricting plan, there was divided government. So we had failure to enact a plan, and we had vetoes, and we had the courts step in. If the House and the Senate are controlled by the same party, but the governor is of a different party, as we had in 2001, for example, the House can pass its plans, the Senate can pass its plan and go to conference committee, come out with bills, send them to the governor, who's going to veto them, because they haven't spent any time at all trying to negotiate with the minority, because they don't have to in order to get the bills passed through their bodies. if the
Well,
House
that
and
was,
Senate
of
are
course,
controlled, go ahead.
I was going to say, well, that was, of course, the interesting situation in 1991, when a veto was cast by Republican Governor Arnie Carlson of the DFL legislature's bills, but the veto wasn't properly cast. And so that bollocksed up the situation considerably.
So they passed the bill by accident because nobody expected the legislators who were passing that bill through the House and the Senate had every expectation that the governor was going to veto it. How did they know that he was going to be late with his veto message and it would become law without his signature? It was an accident.
That's right.
And the court had to repair it. If we have a situation like the current one where the House and the Senate are controlled by different parties, each house can pass a pair of plans. Congress and legislative could go to conference, but the conferees won't be able to agree because they're so committed to the bill that they got through their own body. They're not going to yield to the other side, especially when they know the court will do it. It's always their decision. Can we get a better deal negotiating with the other party than we can get from the courts? And they've always decided, I think we'll do better with the courts than we can with those SOBs and the other party.
Well, I'm pretty clear that that is a good description of the legislative attitude, but I know you well enough to know that you're not crazy about this state of affairs, this status quo of the de facto arrangement that we have of the courts becoming our redistricting commission in this state. Is there a better way, Peter?
Well, maybe. My thought and the thought that I proposed to the leaders involved with redistricting at the start of the 2021 session in January, I went to various leaders and said, let's turn the process upside down and backwards. Instead of starting at the bottom, let's start at the top. Start with the House and Senate leaders. Get them together to talk about how they might find common ground. Let them appoint a bipartisan joint redistricting committee to act as if it were a conference committee at the very beginning. Pre-conferee bill. We do that with a few other issues. Direct the staff to start with maps that both parties could accept. And what kind of maps would those be? Well, they would recognize that, again, looking back at Minnesota's political geography, there are going to be large areas of the state where one party is going to win the districts, however they are drawn. Let the Republicans draw those red districts in the rural areas and let the Democrats draw those totally blue districts in the urban areas. Then all we really need to talk about is those suburban districts that are going to be competitive because they're a mixture of Republicans and Democrats, and they are changing rapidly. It's a mistake, I think, by legislators of the last 50 years or more to give each incumbent a veto over his or her district.
Well, that's been the rub, hasn't it?
They ought to go to those people last, to treat it at the higher level first.
This is going to be a hard slide for our folks to read here. I think.
No, you're not going to be able to. You're not going to be able to see it. If the slides will all be posted on the Clean Elections website later, and you can zoom in on this one and read what it says then. But I'll just tell you what it says. This has all of the districts in a hypothetical plan ranked in accordance with their partisan lean, so that the safest districts are up at the top and the most competitive districts are down at the bottom. It's called a swing to lose pendulum. I won't go into that, but so this particular plan has 38 or 39 Democratic districts and 28 Republican districts. But if you look at the districts that are not competitive, well, if you look at the districts that are competitive at the bottom, you've got 11 Democratic districts and 5 Republican districts. 16 districts are competitive. Now, my math says if you subtract 16 from 67, you're going to get 51. 51 districts that are not competitive. 51 districts then can be drawn any which way, and the same people are going to win. So couldn't some of those 51 people get together on a map where they don't have this great worry about being drawn out of their district or being defeated? They can get by with about anything.
But the rub is, can the leader of the caucus hold his or her powerful seat if that many of the members of the caucus are unhappy with the redistricting map?
Oh, probably not.
There's the rub.
And that's why it doesn't happen. Because the leaders, they don't want to take heat from any of those people who are down in those competitive districts. They can't afford to lose just a few of those people. They've got to go to bat for every single one. And that's why they let the courts do it.
All right. So that leads to the ideas about a commission as the approach that we ought to take. And some states have done this, right?
Yes, they have. But the states who have done it are states that have the initiative. Not all of them, but most of them are states that have the initiative. And I think most people on this call know that the initiative allows citizens to get together, sign a petition, and put something on the ballot in November that will change a law or change the Constitution, even if it is opposed by the legislature. We don't have that system in Minnesota.
No.
And so we have to take a look at, what did the current legislators want? Are they willing to create a commission? And my answer has been, over the last 2.5 years that I've been lobbying the legislature. Lonnie actually got me into this. She asked me to draw a bill that created a commission so she would have something to lobby the legislature with, and I did, and then I ended up lobbying it myself. Sorry, Lonnie. But as I've talked with members, and I've talked with more than 100 of the 201 members of the legislature during 2019 and 2020, most of them said, I like my district. It elected me. My district was drawn by a court. How about we just have the courts draw the new districts? Then I'll probably get a district that I like. Because I know that the courts can't get too creative. The courts have to do what we call a least change plan. Just solve the constitutional problem, equalize the populations of the district, and don't do any other creative things. That's probably going to be good for me. I'll take my chances with the court.
Well, and of course that winds up meaning that any flaws in the current plan it would be perpetuated for decades and decades, right?
Yes. Yeah. And
so, but you've often said to me, Peter, you don't think the courts should be in this position. Explain that point of view.
Well, I listened to former Chief Justice Kathleen Blatz talk to the Senate Committee on State Governmental Operations back in 2008, January, when the Mondale-Carlson coalition came in and presented their plan for an advisory commission to be created by law, not by a constitutional constitutional amendment, in order to take the court out of this, because as she said, we don't belong in this business. We don't want to be tarnishing our reputation for independence. And if we get into these partisan political battles, that will hurt our reputation. Plus, we don't have the expertise. We've got one kind of expertise, but it's not the expertise in balancing political interests involved when we're deciding what district to put various groups of voters in. So please don't make us do it. And the Senate, by the way, passed that bill, a version of that bill, in 2009. And I happened to see the Speaker of the House in the hallway during that summer, and she said, Peter, you know, we're not going to pass that bill. Mm-hmm. And the reason why they didn't want to pass the bill is because they were convinced that this time it's going to be different. This time, one party, and it's going to be Democrats, we're going to control the legislature because the whole process, because we currently control the House and the Senate. There's a Republican governor, but we're going to elect a Democratic governor and we're going to run the table in 2001. And that didn't happen, did it?
Politicians are such optimists, aren't they? They always are waiting for that happy moment when they think their party will be completely in charge. In Minnesota, it's been very rare that that's happened.
Yep. Everybody wants to run the table, but it
That's
doesn't
right.
happen.
That's right. So you, though, are enough of a realist about this process, having watched it so many times, that you expect that the courts are going to function. And yet we have hearings as recently, as soon as tomorrow, we'll start some hearings in the Senate. We've had some hearings in the House. Help us understand what's going on at the legislature about the public hearings. What is the scenario now going forward?
First, a little bit of history. That in the past, it's been normal for the legislature, the legislative committees, to do what the House and Senate are doing right now and go out in a series of hearings around the state and take testimony from citizens before drawing a plan. The last 2 decades, not the first 3, but the last 2 decades that the court has been drawing plans, they have gone out also with that kind of hearing before drawing a plan. The House has already had this one series of hearings in August and September. And the Senate has had, I think, 1 hearing. They have another one on Thursday morning at 10 in Lakeville to take testimony from people. The earlier hearing was in Bemidji, I think. And they may or may not have more. And the court has posted a schedule on their website for hearings in October. But I just checked their website, by the way, today, and the deadline for people to sign up to testify passed last Thursday, the 24th. And so you can't sign up, but you can watch. They're going to be on Zoom. They will be in-person hearings around the state, except for the very last one, which will be only Zoom. But you can watch, but it's too late to testify. But you can submit written materials. You can continue to submit written materials at any time. Okay, so that's the past practice, and it is continuing right now as we speak.
Okay. And are you of the opinion that what we're seeing in the legislative branch, legislative bodies, is mostly for show, and what the court is doing is the real deal?
Well, it's a little too early to tell for sure. One would suspect that, because the idea of having a hearing on a preliminary plan, a hearing on a real plan, taking real testimony, it's never been done before.
Okay.
The bill that Lonnie got me started with, and Representative Jennifer Schultz carried in the House and Senator Ann Rest carried it in the Senate, required the Redistricting Commission that it created to have 2 sets of hearings. One before a plan was proposed by the commission, and one after, in each congressional district after it was proposed. Representative Jenny Cleavorn has a bill introduced this year in May with a similar requirement. Got to have a hearing after you have proposed a plan. And to my great surprise, at the last hearing of the House committee, Chair Mary Murphy announced, okay, we've finished this round of hearings before we draw a plan. Now we're going to have some more hearings and develop principles. We're going to do it in public. We're going to take some votes. And then we're going to produce draft plans. And she said, we're going to hold another set of hearings around the state on those draft plans. I almost fell over. This would be revolutionary if they did that. So maybe it's not just for show.
So maybe it's not just for show, but if the House and Senate fail to agree, as we suspect it will be likely, since the House and Senate are in different partisan hands, will the courts be influenced by what happens in these 2 bodies with regard to the maps that they may come up with?
The court has always taken testimony from the parties that included evidence of what was turned up at these public hearings. The Republicans in the Senate, if we're in this kind of a situation, would have people testify at hearings that said good things about what the Senate ends up doing. The parties in court will take that testimony and present it to the court. In the hearing in Bemidji, Joe X said, do it this way, and that's what this plan does. Same thing with the Democrats. They will put that testimony in. So it will have some impact, perhaps, on what the court does, even if it is the court adopting the plan rather than the legislative body.
Okay, but the interesting thing is you, as the chief plaintiff, you and your colleagues have also submitted a plan, which I'm sure will be similarly influential. Peter, we've only got about 10 minutes left in this very interesting program, and so I'm wanting to get to some of the questions that we've had submitted to us. And there's a good deal of interest in the notion of an independent redistricting commission. You said a moment ago that states that have done that have typically had to rely on a ballot initiative to get that thing passed. We actually put something like that on the ballot in 1980, as I recall, when you and I were just kids at the Capitol, and it didn't pass. It was the year that they put lots of things on the ballot, I think in the expectation that the more they put on the ballot, the fewer of them would pass, and that happened. Is an independent commission going to be a good idea at any point for Minnesota? And if it would be, how would we ever get there?
Well, I think it would be a great idea. We're not going to get there unless we persuade members of the legislature that it's a good idea. And it would appear from my conversations with people over the last 3 years that they're all going to wait for 2030. Oh boy, you just wait, 2030. My party is going to control the whole process. And so, no, we don't want to give this up to a commission.
And without a citizen, an opportunity for initiative and referendum, as other states have had, does this have to be done by constitutional amendment? Can the legislature involve an independent commission short of a constitutional amendment?
Oh yes, the legislature could create an advisory commission so that they held the final say over the plans, but still ask some outside people to draw up the plans for the legislature to consider. And that was one of the aspects of the bill that I worked on. So if they wanted to do it, a vehicle is there for them to do it, but they don't want to do it.
And where we started this conversation was your reflection that right now the action and all this really does lie with the states because the feds have chosen not to play. But there are bills in the Congress right now that do speak to redistricting. Is that not right?
Yes, yes, indeed.
Say a little bit about that, if you would.
What's the latest name of it? The Freedom to Vote Act includes standards for redistricting that are a little bit similar to what is in my proposal. That is an attempt to ensure that the plan will cause people to be elected who are likely to represent a majority of the population. They have a little bit different statistical tests that they have written into the law, but it's the same idea. Let's take a look at election results, try to predict how this plan will perform, and not be able to adopt a plan that will perform by allowing a minority of votes statewide to elect a majority of the members of the legislature. That is just in that bill.
Well, and maybe that would get us back to your wonderful slides that you've prepared here. When you have a slide that's headline, "Will a fair map in Minnesota lean DFL?" I think that's your slide number 25. Let's take a look at that slide. There we go. This again goes back to how do you decide whether a map is fair?
Well, I think a fair map, take a look at that bottom, is one bottom bullet. If a fair map is one where the party that receives the most votes statewide wins the most seats. So let's take a look at how the statewide vote has gone over the last decade, is the test in my proposal to the court. Well, what kind of a state is Minnesota? Well, let's take a look. We haven't voted for a presidential candidate from the Republican Party since Nixon, Richard Nixon, 1972. We haven't elected any Republican to a statewide office since 2006, 15 years. Is that the sign of a purple state? I don't think so. If you add up all the votes for those partisan federal and state offices in the last decade, the statewide votes, not Congress or the legislature, in the last decade, they've favored DFL candidates by more than 8%. So by my definition of a fair plan is one that will lean DFL.
Yeah. The least change philosophy of the courts, a philosophy that's going to get us there with regard to a fair map, do you think?
Oh, I think it could. I think it could, because I have proposed to the courts, many of the people on this Zoom have seen my proposed congressional map based on the 2020 census. And I believe it's a fair map. It's a 4-4 map, but with the 3 competitive districts, congressional districts, that could be won by either party. A swing of 1 or 2%, 3% either way could make it a 6-2 plan rather than a 4-4 plan. I think that's a plan that, depending on how the people vote statewide, that will be who has the majority of seats in Congress from Minnesota. You haven't seen my Senate plan yet because we haven't finished deciding what it's going to look like, but it will be something like that. I think it can be done.
Yeah. Well, we also have had some questions, Peter, from some listeners concerning minority voting power in Minnesota. Has minority voting power been fairly reflected in Minnesota's redistricting plans? Is this a consideration that has come to the attention of the courts, and what will be the court's response with regard to minority votes, racial minority votes, as it considers its task this time around?
This is going to be one of the toughest tasks for this particular state court panel, because in the last couple of elections, and particularly in the 2020 election, there have been a lot of minority candidates elected from majority white, non-Hispanic districts. So these are not evidence, those elections are not evidence that there is racially polarized voting, because minority candidates can win in a white, non-Hispanic district. In fact, most of the elected minority candidates are from white majority districts. But it's also true that as you redraw the map, and I talked about all that mixing, all that activity, all that change that's going to occur in the Twin Cities suburbs, that's where a lot of those representatives were elected for the first time in the last 2 elections. And they're going to get put together into the same district. I tried in my earlier plans to avoid pairing incumbents, particularly minority incumbents, but I couldn't do it. They're just too close to, they're too much shift in the district boundaries for people who live so close together.
Well, and let's explain.
What's the court going to do? What's the court going to do?
Yeah, and let's explain that in state law, representatives must live in their districts. That's not true with the federal situation with members of Congress, but it is true in state law.
Yes, yes. So I think we're going to have a situation where the Voting Rights Act does not compel the drawing of districts that would favor minority candidates, because there's no evidence of racially polarized voting. Minority candidates are winning in white majority districts. Right. So they don't have to draw a district like that. But there are these people who are there right now, and their district could be drawn in such a way either to pair them, which is, in my opinion, it's bad, or to make it very difficult for them to win.
Right, right.
So I don't know what the court is going to do about that. It's going to be a very tough problem for them.
Very, very tough problem.
Especially when their attitude is, in the past, the attitude has been, we're not going to look at the partisan political implications of our plans. We are not going to consider election results. And we're not going to look at the residents of incumbents when we are drawing our plans. We're not going to know if we have pitted 2 of those minority incumbents in the same district. They won't even know. But we will take a look at the very end, and if there's something egregious, we will make small changes to fix it.
Well, and to the extent there is a perceived problem, there will be an appeal, and the federal courts will stand if there is evidence of a racial problem, racial gerrymandering. Is that right?
The appeal of this panel's decision would be to the Minnesota Supreme Court itself. So if there is a challenge to the panel plan, it won't be in the nature of an appeal. It would be in the nature of a federal court challenge, a collateral attack.
Okay, okay.
So a new suit brought in federal court alleging that the state court violated the Voting Rights Act. I think that will be a hard one to prove.
Yeah.
for the reasons that I said, but doesn't mean the suit can't be brought.
Well, which leads us, we're running low on time here, and I want to ask a question about time. Talk then, if you would, Peter, about the timeline for this big every 10-year project, and for the time that remains, if there is any, for citizens to get involved and have their voices heard.
Well, unfortunately, the deadline for citizens to sign up to speak at the court's hearings has passed on the 24th of September. But citizens can continue to submit written testimony to the federal court panel. I don't think they'll have a second set of hearings on their draft plan. They never have. Citizens can very much testify if there is indeed a second round of House hearings on a proposed plan. Citizens can testify at the Senate hearings. Now, this one on Thursday is the only one that's been scheduled so far. And in fact, on the House side, even though the chair said there would be more hearings, there are none scheduled yet. So I think the people on this Zoom are going to want to keep an eye on, sign up for emails from the House and Senate committees, and keep an eye on the court's website to see if there are more opportunities. And at least if you've got something you can put in writing, put it in writing, send it to the court. They'll look at it. They'll look at it.
All right. Well, that's the opportunity that people have. It may not be as satisfying an opportunity as other activities we do in democracy, but oh my, we are at an important moment in assuring the fairness and the confidence that people continue to have in our system. And as you know, and as our listeners here know, we've been having a deficit of confidence in our system in this country. Getting redistricting right will go, I think, a long way to making people continue to feel good about democracy and how we can shape our shared lives. So Peter, thank you. It's been great fun to talk to you about all this tonight. And thanks for these great slides. And
Thank you,
thanks to
Lori.
our listeners as well.
And thanks to all of you for tuning in.
That's right. Good night.
Good night.